Hello, law students and legal practitioners. Today, we will analyze the case of Korea Technologies Company, Limited vs. Lerma, GR number 143581, decided by the Supreme Court on January 7, 2008. Let's begin. An arbitration clause mutually agreed upon by the parties, including one providing for arbitration in a foreign country and declaring the arbitral award final and binding, is valid and not contrary to public policy. An arbitration clause does not oust Philippine courts of jurisdiction. Courts retain limited jurisdiction to grant interim relief, refer parties to arbitration, and review or enforce arbitral awards in accordance with Republic Act No. 9285 and the UNCITRAL model law. Where a contract contains a valid arbitration clause, neither party may unilaterally rescind or terminate the contract nor seek judicial relief on matters covered by the clause without first resorting to arbitration. Foreign arbitral awards, although declared final and binding by contract, are not self-executory and must be confirmed by Philippine courts before enforcement. They remain subject to judicial review on specific statutory grounds. Here are the relevant facts of the case. Korea Technologies Company, Limited, KOGIES, a Korean corporation engaged in supplying and installing LPG cylinder manufacturing plants, entered into a contract dated March 5, 1997 with Pacific General Steel Manufacturing Corporation, PGSMC, a Philippine corporation, for the establishment of an LPG cylinder manufacturing plant in Carmona, Cavite. The contract price amounted to $1,530,000 United States dollars, covering the supply of machinery and equipment, installation, and initiation of plant operations. The parties later executed an amendment in Korea modifying the terms of payment. PGSMC paid KOGIES $1,224,000 United States dollars for the machinery and equipment. However, the remaining balance of $306,000 United States dollars for installation and initial operation was covered by two post-dated checks issued by PGSMC, both of which were later dishonored due to a stop payment order. Disputes arose when PGSMC alleged that KOGIES delivered machinery of inferior quality and failed to fully install and make the plant operational. KOGIES denied these allegations, claiming that PGSMC's financial difficulties prevented the procurement of raw materials necessary for initial operation. PGSMC eventually declared the contract cancelled and threatened to dismantle and transfer the machinery. Despite the existence of Article 15, an arbitration clause providing that all disputes be finally settled by arbitration in Seoul, Korea under the rules of the Korean Commercial Arbitration Board, KCAB, PGSMC filed criminal and civil actions in the Philippines. In response, KOGIES initiated arbitration proceedings in Korea and filed a complaint before the RTC of Muntinlupa seeking injunctive relief. The RTC denied KOGIES' application for injunction and declared the arbitration clause void for being contrary to public policy and for allegedly ousting the courts of jurisdiction. The Court of Appeals affirmed the RTC. Hence, KOGIES elevated the case to the Supreme Court. Here are the issues and ruling of the Supreme Court. Issue 1. Whether the arbitration clause providing for foreign arbitration and declaring the arbitral award final and binding is valid. Yes, the arbitration clause is valid and enforceable. Article 2044 of the Civil Code expressly recognizes the validity of stipulations declaring arbitral awards final and binding. Republic Act No. 876, the Arbitration Law, and Republic Act No. 9285, Alternative Dispute Resolution Act of 2004, embody the state policy favoring arbitration as an alternative mode of dispute resolution. The Philippines is a signatory to the UNCITRAL model law and the New York Convention, both of which recognize the validity of international arbitration agreements and foreign arbitral awards. Republic Act No. 9285 incorporated the UNCITRAL model law into Philippine law, mandating courts to refer parties to arbitration when a valid arbitration agreement exists, unless such agreement is null and void, inoperative, or incapable of being performed. Arbitration clauses are contracts in themselves. A freely and voluntarily agreed arbitration stipulation is binding upon the parties and cannot be disregarded absent a showing that it violates law, morals, good customs, public order, or public policy. The arbitration clause in Article 15 was mutually agreed upon by KOGIES and PGSMC. It was not shown to be contrary to law or public policy. The stipulation that arbitration be conducted in Korea and that the award be final and binding does not invalidate the clause. Hence, the lower courts erred in declaring it void. Issue 2. Whether the arbitration clause ousts Philippine courts of jurisdiction. No, the arbitration clause does not oust Philippine courts of jurisdiction. While courts must defer to arbitration on the merits of disputes covered by a valid arbitration agreement, they retain jurisdiction to 1. Refer the parties to arbitration, 2. Grant interim or provisional relief, and 3. Review, confirm, vacate, or enforce arbitral awards under Republic Act No. 9285. Under the UNCITRAL Model Law and RA 9285, foreign arbitral awards are not self-executory. They must first be confirmed by the regional trial court before enforcement, and may be refused recognition on specific statutory grounds. Thus, judicial review is preserved. Although the arbitral tribunal in Korea has primary jurisdiction over the substantive disputes, Philippine courts retain supervisory jurisdiction. The arbitration clause therefore does not deprive courts of authority, but merely limits judicial intervention consistent with the law. Issue 3. Whether PGSMC may unilaterally rescind the contract despite the arbitration clause. No, unilateral rescission is improper. Where a contract contains a valid arbitration clause, disputes regarding breach, compliance, rescission, or termination must first be submitted to arbitration. The doctrine allowing provisional unilateral rescission does not apply when the parties have expressly agreed to arbitrate disputes. Allowing unilateral rescission would defeat the purpose of arbitration and violate the parties' contractual undertaking. PGSMC's unilateral cancellation of the contract and resort to judicial remedies without prior arbitration violated Article 15 of the contract. All issues regarding alleged breaches should have been submitted to the KCIB. Issue 4. Whether the RTC committed grave abuse of discretion in assuming jurisdiction over arbitrable issues. Yes, the RTC committed grave abuse of discretion. Republic Act No. 9285 mandates courts to refer parties to arbitration when the subject matter of the action is covered by a valid arbitration agreement. Any judicial determination of the merits of arbitrable issues constitutes grave abuse of discretion. By ruling on ownership, installation defects, and contractual compliance, matters clearly covered by the arbitration clause, the RTC exceeded its authority. These issues fall under the exclusive competence of the arbitral tribunal. Thank you for listening and happy learning. Please don't forget to subscribe to the Legal Shepherd PH YouTube channel and click the notification bell to stay updated on newly uploaded cases and jurisprudence. See you again for our next case discussions.